An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman. Does the First Amendment protect tortious speech? New York Times Company versus Sullivan, 1964. Snyder versus Phelps, 2011. All liberty may reasonably be regulated to protect the rights of others. The freedom of speech is no different. For example, no one thinks that the, quote, right of freedom of speech includes the right to commit the tort of fraud. The elements of the tort of fraud define wrongful behavior, and wrongful behavior may be prohibited without violating the Constitution. The freedom of speech is no different. Defamation and the intentional infliction of emotional distress are also torts that wrongfully violate the rights of others. Does the First Amendment provide any limit on these causes of action? The two cases in this video hold that the answer to this question is yes. Let's start with New York Times Company versus Sullivan and the defamation tort. Slander is defamation communicated by oral or spoken words. Libel is defamation communicated by fixed words, such as those that are printed. In Sullivan, a government official brought a libel action against New York Times Company for publishing false statements in an advertisement. In March 1960, a civil rights group published a full-page advertisement in the New York Times. Law professor Herbert Wexler represented the newspaper. He described the advertisement.
It was published on behalf of a committee to defend Martin Luther King and the struggle for freedom in the South.
The advertisement recounted how
thousands of Southern Negro students are engaged in widespread nonviolent demonstrations. They're being met by an unprecedented wave of terror. The lead caption, "Heed Their Rising Voices," is a phrase that's taken from a New York Times editorial, which indicates accurately the sympathy with which this newspaper has viewed the Negro protest demonstrations in the South.
The purpose of the advertisement was clear.
The object of the publication was to obtain financial support.
Readers were encouraged to cut out the form on the bottom right hand of the page and mail in a check. Study guide. Should the New York Times Company's advertisement receive heightened protection under the First Amendment? Or does it receive reduced protection as mere commercial speech? However, Wexler acknowledged that the advertisement
was indeed inaccurate in some particulars, and I would like to state as faithfully as I can what those inaccuracies were.
First, the advertisement stated that
truckloads of police armed with shotguns and tear gas ring the campus. The evidence doesn't show that the police ever ringed the campus in any literal sense.
Second, the advertisement stated that the student
dining hall was padlocked in an attempt to starve them into submission. The ad was wrong in stating that their dining hall was padlocked in an attempt to starve them into submission. There's no evidence that the dining hall was padlocked.
Third, the advertisement stated that Martin Luther King was arrested
7 times.
That assertion was also inaccurate. King
was arrested not 7 times, to be sure, but it was established that he was arrested 4 times.
After the Times published the advertisement, a libel action
was instituted by the respondent, Mr. L.B. Sullivan, one of the 3 elected commissioners of the city of Montgomery, Alabama. The complaint demands damages of $500,000 for libel.
I think it's against the law of human nature to want to force something down people's throat. People here in Montgomery are what I think the finest people in the world.
The advertisement did not name Sullivan, but he claimed that the text could be read as imputing to the police, and hence to him, the violent acts against the students. Under the normal standards of the tort of libel, the New York Times published false information that tended to injure Sullivan's reputation. However, the Times argued that the First Amendment limits the application of this tort. Specifically, Wexler said that a judgment against the Times poses
hazards to the freedom of the press of a dimension not confronted since the early days of the Republic.
He questioned
how far the civil law of libel may be used by state officials to punish the publication of statements critical of their official conduct or of the conduct of the agencies of which they are in charge.
Wexler drew inspiration from familiar sources.
We are actually making the same argument that James Madison made and that Thomas Jefferson made with respect to the validity of the Sedition Act of 1798.
He explained that
the First Amendment was precisely designed to do away with seditious libel. And seditious libel was punishment for criticism of the government.
Wexler claimed that
if James Madison were alive today, so far as anything that I can see in the report on the Virginia resolutions, that the submission that I am making was the submission he would make.
On appeal, the question presented was whether the advertisement forfeits First Amendment protection by the falsity of some of its factual statements and by its alleged defamation of respondent. The court unanimously ruled in favor of the Times. Justice Brennan wrote the majority opinion. He announced that the First Amendment limits libel suits for public officials. Here's how he described the test. Quote, "The constitutional guarantees require, we think, a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct unless he proves that the statement was made with, quote, actual malice, that is, with knowledge that it was false or with reckless disregard of whether it was false or not." First, where is a line between a public and private official? Wexler admitted that the distinction may often be fuzzy.
It's criticism of his official conduct that's involved, not his private life, though I admit that that's not an easy line to draw, since obviously private affairs do bear on official competence.
Here, there is no doubt that Sullivan was an elected public official. Second, did the Times act with actual malice? No. The paper did not publish the false information, quote, with reckless disregard of whether it was false or not. The errors were perhaps negligent, but were not made with, quote, actual malice. Therefore, Sullivan could not sue the New York Times for libel. Study guide. Under the state action doctrine, constitutional rights are only violated by governmental acts. What was the state action in New York Times versus Sullivan? In a decade after Sullivan, the court extended the actual malice standard to defamation suits brought by public figures, in addition to those brought by public officials. The Supreme Court has defined public figures as persons who do not work for the government, but who are, quote, nevertheless intimately involved in the resolution of important public questions or by reason of their fame, shape events in areas of concern to society at large. However, the actual malice standard does not extend to defamation suits brought by private individuals. Let's now consider another type of wrongful act, the tort of intentional infliction of emotional distress, or IIED. Chief Justice Roberts described the facts of Snyder versus Phelps.
The members of the Westboro Baptist Church believe that God hates and punishes the United States for, among other things, its tolerance of homosexuality, particularly in America's military.
He explained that
the Church has chosen to communicate these views by picketing at military funerals, and has frequently done so for the past 20 years. Fred Phelps, who founded the church, and 6 Westboro Baptist parishioners, all of whom happen to be related to Phelps, traveled to Maryland to picket the funeral of Marine Lance Corporal Matthew Snyder, who was killed in Iraq in the line of duty. Picketing took place on public land approximately 1,000 feet from the Catholic church where the funeral was held.
the protesters held signs with awful messages.
Thank God for dead soldiers. Fags doom nations. Thank God for 9/11. America is doomed. Hope in hell. And God hates you.
Matthew Snyder's father did not see the signs during the funeral. He only learned about their presence while watching the evening news. Snyder sued Westboro
for intentional infliction of emotional distress, a tort under state law.
After the trial.
A jury held Westboro liable for several $1 million in compensatory and punitive damages.
On appeal,
Westboro challenged the verdict on the ground that the First Amendment fully protected its speech.
Let me put that in some colloquial street talk. You hurt my feelings. The First Amendment says you don't get $11 million.
The court ruled for Westboro by an 8-1 vote. Chief Justice Roberts wrote the majority opinion. Only Justice Alito dissented. First, the court had to decide whether Westboro's speech was about a public or private concern. Chief Justice Roberts concluded that
the content of Westboro's signs plainly relates to broad issues of interest to society at large.
He explained that
the political and moral conduct of the United States and its citizens, the fate of our nation, homosexuality in the military, and scandals involving the Catholic clergy are matters of public import.
In dissent, Justice Alito countered that some of the signs were directed at Matthew Snyder. For example, quote, "You're going to hell," referred to Matthew. In addition to the signs, sometime after the demonstration, Westboro published a blog post known as an epic that addressed the Snyder family directly. During oral argument, Justice Alito stated,
"Do you think that the epic is relevant as an explanation of some of these arguably ambiguous signs that were displayed at the funeral? For example, you're going to hell, God hates you, who is you?" If you read the epic, perhaps that sheds light on who you is.
The majority declined to consider the relevance of the epic because it was not properly before us. Why? Because Snyder never mentioned the epic in his petition for certiorari. In this way, the majority limited its ruling to Westboro's conduct at the demonstration. The court did not resolve whether the sort of message communicated on the internet by the epic could give rise to IIED liability. With respect to the signs at the demonstration, which were part of the case, Chief Justice Roberts observed that
even if a few of Westboro's signs were viewed as containing messages related to Matthew Snyder or the Snyders specifically, that would not change the fact that the overall thrust and dominant theme of the church's demonstration spoke to broader public issues.
By limiting the facts in this way, Chief Justice Roberts made the case easier to decide than perhaps it was. Second, the majority focused on the fact that Westboro protested
at a public place adjacent to a public street. Such space has historically occupied a favored position in terms of First Amendment protection.
Moreover,
the picketing was conducted under police supervision, some 1,000 feet from the church, out of the sight of those at the church. The protest was not unruly. There was no shouting, profanity, or violence.
Third, the majority observed that, quote, any distress occasioned by Westboro's picketing turned on the content and viewpoint of the message conveyed, rather than any interference with the funeral itself. The court concluded, quote, given that Westboro's speech was at a public place on a matter of public concern, that speech is entitled to special protection under the First Amendment. Such speech cannot be restricted simply because it is upsetting or arouses contempt. Chief Justice Roberts cited Texas v. Johnson, which reversed a conviction for flag burning.
If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable.
Justice Alito wrote a solo dissent, quote, our profound national commitment to free and open debate is not a license for the vicious verbal assault that occurred in this case. Petitioner Albert Snyder is not a public figure. According to Justice Alito, quote, in this case, respondents brutally attacked Matthew Snyder, and this attack, which was almost certain to inflict injury, was central to respondents' well-practiced strategy for attracting public attention. Justice Alito acknowledged that most of Westboro's speech was about matters of public concern. However, that fact should not decide the case. He explained, quote, I fail to see why actionable speech should be immunized simply because it is interspersed with speech that is protected. He added, quote, the First Amendment allows recovery for defamatory statements that are interspersed with non-defamatory statements on matters of public concern, and there's no good reason why respondents' attack on Matthew Snyder and his family should be treated differently. The majority disagreed.
Speech is powerful. It can stir people to action, move them to tears of both joy and sorrow, and, as it did here, inflict great pain. On the facts before us, we cannot react to that pain by punishing the speaker. As a nation, we have chosen a different course to protect even hurtful speech on public issues, to ensure that we do not stifle public debate. That choice requires that we shield Westboro from tort liability for its picketing in this case.
Study Guide. Do the dignitary torts of defamation and intentional infliction of emotional distress implicate the First Amendment in ways that fraud does not? Hint. Who was the communication directed at in Sullivan? In Snyder, what was the subject of the communication?